All right, just let me know when we're live.
Okay. All right, we're live again.
All right, thank you, Ms. Pam. All right, line item 0744-21, communication sponsored by Mayor Mason seeking approval to enter into developmental incentive agreement with Hobby Properties LLC regarding the redevelopment of the site located at or near 233 Lake Avenue. Staff recommendation is move to approve the item as presented.
Move to approve as presented.
Yep, second.
All right, moved by Alder Tate, seconded by the chair, Taft. All right, right now, all those in favor say aye.
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 All those opposed say no. Motion passes. All right, next line item 0752-21. Communication sponsored by Mayor Mason requested that the city attorney brief the Finance and Personnel Committee concerning negotiations with the city's protective services unions regarding the impact of Resolution 0690-21, requirement that the city of Racine employees comply with certain COVID-19 public health protections on police and fire union personnel. Staff recommendation is to receive and file.
Move to receive and file.
Second.
Second.
All right, moved by President Tate and seconded by Alderman Meekma. All those in favor, say aye.
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 Oppose? Motion carries. All right, moving on. Sorry about this. Getting my paperwork together here. All right, line item 0745-21, communication sponsored by the Vice Chair on behalf of Police Chief Robinson to apply for 2022 Beat Patrol grant from the Wisconsin DOJ, grant number 00391. Staff recommendation is the approval to apply for the 2022 Beat Patrol grant. Fiscal note, grant amount is $121,434. City match of $40,478. All right, who will we have speaking to this line item today?
Hi, that's me, Deputy Chief Montoya. How are you?
All right, how are you doing, Deputy Chief?
Do you guys have any questions? This is a grant that we redo every year, I think. It covers 2 extra Beat Patrol officers for the community policing unit. I think it's 75% of their salary and benefits, and then the city kicks in 25% more.
Thank you, Deputy Chief. Any questions, discussions? All right, seeing none, I'll entertain a motion.
Second.
Sorry, let's go back. President Tate, you have your hand up.
Yeah, I just had a quick question. If RPD has budgeted for the 25% match already?
Yeah.
Okay, thank you.
All right, seeing no more hands, I'll entertain a motion right now.
Second the motion.
All right, I think it was moved by,
Yeah.
was it
Who
moved by
moved it?
President Tate first before the question, or?
Yeah. Move to approve.
All right, seconded by Alder Pete.
Just
Thank you.
rare in a second, that's all.
All those in favor, say aye.
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 All those opposed, say no. Motion carries. Thank you, Deputy.
Thanks, guys. Have a good night.
Who was the mover on that one? Okay,
Yeah, Taft and Pete.
okay, thank you.
No problem. Thank you very much. All right, moving on. Next line item 0749-21, communication sponsored by Alder Peterson recommending that fully vaccinated Non-represented City of Racine employees who test positive for COVID-19 shall be granted paid administrative leave during any isolation period required by the July 29, 2021 deadline. Racine employee COVID-19 temporary policy or any amended or successor Racine employee policy. Staff recommendation to approve the communication. Anyone speaking to this line item today? All right, I see a bunch of hands. All right, we'll go with the chair tab first. You're muted.
No, thank you. I just had a question about the time frame. So I think, can we link it to the CDC guidelines? I guess I would move to amend it to link it to the CDC guidelines like what they require for time. Yeah, but I feel like that was unclear in the motion.
Can you?
Well, I'm not going to move to
Aye.
amend it yet because then we have to just discuss the amendment, but I'm going to say that that's what I want to do. So I rescind my movement until such time as we finish discussion.
All right, Attorney Lidney.
Thank you, sir. I'm trying to pull up the policy so I can be really intelligent about it, but the mayor issued he's had continuing policies throughout the entire period of COVID about how employees are handled. And at the end of July, he issued a new policy that included guidelines as drafted by the public health administrator. And so that's the policy that's referenced, that July 29, 2021 policy.
Okay.
That policy is specifically defined based upon CDC guidelines. And so what that policy says is there's specific procedures for all kinds of situations. The one for those who test positive for COVID-19, it's different depending on whether they have symptoms or don't. Those that do have symptoms must isolate until at least 10 days past symptom onset and at least 24 hours past no fever without medication. And those without COVID symptoms have to isolate for 10 days after the date of the test, as long as no symptoms developed. And isolation is defined in the policy. So
Okay, I am fine with that then. That makes sense.
Okay.
Thank you for that clarification.
All right, Mayor Mason.
Thank you, Alder West. Yeah, I did want to speak just in favor of the effort behind it. I mean, prior to early on in the virus, people may remember, although it feels like forever ago, that the federal government actually mandated that employers allow for leave for people who got vaccinated in hope that they would stay home and isolate if they were contagious. We're faced with an exception to where people are with vaccinated, where people may have done everything we asked them to do, yet still get a breakthrough case. And in those instances, it seems reasonable to allow for the 10 days administrative leave, as we did early on in the virus. Because if our employers have been following the CDC rules and doing everything that we've asked them to do and still somehow wound up with a positive case, it seems only fair to give administrative leave for those employees who've been doing everything we asked them to do, but nonetheless still contracted COVID. Thank you.
Thank you, Mayor. President Tate, you have the floor.
Hey, Mr. Chair, I echoing the mayor, I'm in support of this in principle. Certainly, if you did what you were supposed to do and got vaccinated when it was made available to you, and you happen to fall in the unfortunate category of a breakthrough case, 1 in 5,000 or 1 in 10,000 in certain numbers, certainly we want to make sure that folks, for no fault of their own, continue to maintain. One of my concerns is, if this period is up to 10 days, 2 weeks of, business weeks, if you would, of work, I don't want to necessarily kind of incentivize people to be less vigilant in their COVID precautions because they know they'll have that time off with really no other than being infected, fiscal consequences. I floated the idea, and I've been thinking about like maybe we should split the balance of 5 days administrative leave between the 10-day quarantine and 5 days out of one's sick time, something to that effect. Because I think there is a balance to ensure that folks are still being vigilant and not feeling like, well, if I get sick, I might get sick, whatever, but I'm going to go to this party, or I'm not going to wear a mask indoors, or I'm going to go to this concert because, whatever happens, and the city will cover my time off. And that's a bit of my concern as it relates to the full paid administrative leave as opposed to some piece coming from the employee. But that's kind of where I'm at. Certainly want to provide some time off for those who contract that are vaccinated, but I'm wondering if we should be considering a balance between the employee putting forth some of their sick time and the city providing some paid time off as well.
Thank you, President Tate. Alder Pete, you have the floor.
Thank you, sir. I'm a person who, first of all, I agree with both President Tate and the mayor on this issue. I am one of those people last year, and might happen again this year because I work in the school system. I've been in that quarantine, stay-at-home situation, even though I've been fully vaccinated on at least 2 occasions. It may happen again. So my point is that we do have to take what Alder Tate said in consideration. While I did what I was supposed to, I know of people who, and again, I do happen to have sick time, but my employer, when the federal funds ran out, it's like if you quarantine, and especially if you're not vaccinated, you have to use sick time or what have you. So it is a valid point, is what the point I'm trying to make. Sorry to use the same word in the sentence, but we need to take that into consideration. Thank you.
Thank you, Alder Pete. Mr. Von Holt, you have the floor.
So I feel like I need to comment since I was the one who kind of interjected this last week in the debate. And I would remind people that it was a motion on the floor to make this decision and to extend this without vetting and kind of giving it consideration. And I would just say, I have come to my advice and the conclusion and in consultation with the mayor and his goal objectives. And I think the council's goal objectives are, we want people to get vaccinated and we want to lower any kind of barrier or any kind of consideration or any kind of disincentive not to become vaccinated. I think this is a very reasonable policy. Administrative leave is just that. It is bankable time. It is not, other than having to be managed by the services that we provide in departments that have to manage those services for the time off and to manage all of that and the potential, I guess, for overtime in some public safety situations. I think it's a very reasonable thing to do. And again, another olive branch incentive to our employees to go get vaccinated. There is no reason not to. And I really don't think that I would advocate at this point, having thought about it, again, with the mayor's consultation, the attorney's consultation, the commissioner of health's consultation, Kathleen's consultation on budget impact. I think this is the way to go to, again, remove all barriers to becoming vaccinated and any arguments against it.
Thank you. Chair Taff, you have the floor. You're muted, Chair.
Thank you. I appreciate, President Tate's point, and I totally understand that. But I think that the incentive to get vaccinated sort of outweighs that, and also I just don't think there's any way really to evaluate folks' behavior not on work time. And so I think the full, just giving everybody who's fully vaccinated the time is the way to go here, personally.
Any further discussion on line item 0749-21? Seeing none, I will read the physical note for 0749-21 before I entertain a motion. All right, physical note, because paid administration leave will be granted, there will be no payout to employees and no other costs except to provide staffing during any absences due to any employee's isolation, period. My apologies for not reading that earlier. Right now, I'll entertain a motion.
Move to approve.
Second,
All right, moved by President Tate and seconded by Alder P. All those in favor say aye.
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 All those opposed say no. Motion carries. All right, moving on to line item 0702-21, communication sponsored by Alder Taft on behalf of the City Attorney's Office, submitting the claim of Beth Desert, I don't know, beg your pardon if I butchered the name, for consideration for disallowance, staff recommendation, the claim to be disallowed. I'll entertain a motion at this time.
Can we get a background
I
on
think
this?
Attorney Rubik wants to speak to it
Oh.
first, right?
I moved too fast.
I would be happy to speak to it if that's your choice. I also like just straight up motions, but Beth Dessert, the claimant in this matter, filed a claim with the city requesting $382
Uh-oh.
and 85 cents in damages because a ball hit from Horlick Field allegedly hit her tail light as she was driving down Carlisle Avenue and caused some damage to her vehicle. The claim itself, it never says anything about a City of Racine employee. It obviously, the city can't control where foul balls fly and what they hit, unfortunately. But because this was not due to the actions of a city employee, the city's not liable for this damage, and
Your signal is choppy.
I
Yeah.
think Attorney Rubik is saying the city's not liable for this and recommend that the claim be disallowed.
Thank you, Attorney Whitney. And sorry, Ms. Rubin.
yes, I apologize for a choppy signal.
Okay. We heard
Move
it
to
loud.
approve.
Hands up.
Okay, our President Tate has his hands up, Chair.
Just quick
Sorry.
comment. I mean, obviously, if the event occurred as it was, while driving and then getting hit by a foul ball, that's $1 million shot more than 382. But yeah, there's nothing the city can do to stop that from occurring. So I'll move to disallow.
Second.
All right, moved by President Tate, seconded by Chair. All right, all those in favor say aye.
Aye.
Aye. All those opposed?
Aye.
Motion passes. All right, on to the next item. Line item 0703-21, communication sponsored by Alder Taft on behalf of the City Attorney's Office, submitting the claim of Cheryl Christensen for consideration for disallowance. Staff recommendation, the claim to be disallowed. Who will be speaking to this line item today? Ms. Rubik?
Yes, sir. Thank you. And if I continue to have connectivity issues, please let me know and I'll turn off my camera, which usually improves things. So Cheryl Christensen of Racine, Wisconsin, filed a claim with the City of Racine on or about June 21st of 2021, and she was asking for anywhere between $400,000 to $10 million in alleged damages arising from an October 16th, 2020 incident where police officers entered her home and under the community caretaker doctrine. because this claim was not timely filed within 120 days of the event giving rise to it, which is a statutory requirement when filing claims, it's a recommendation of my office that the claim be disallowed.
Move to disallow.
Second.
All right, moved by President Tate, seconded by Chair Taft. All those in favor say aye.
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 All those opposed? Motion carries. Thank you. All right, next line item 0704-21, communication sponsored by Alder Taft on behalf of the City Attorney's Office, submitting the claim that Eugene Inocencio for consideration for disallowance. Staff recommendation, the claim be disallowed.
This is me again.
Hello.
Mr. Eugene Inocencio filed a claim with the city requesting $1,595 in damages for home repairs that were caused allegedly from a tree falling onto his home, his roof, on or about July 5th of this year. His house is located at 1723 Green Street. There was a big storm that night. However, the city had no prior notice of a defect in this particular tree. It had been inspected on schedule. Last June, it had been pruned a bit in September, and at that time, nothing was detected as of concern. When the city has no notice of a defect in a tree, it does not have what's called a ministerial duty to service the tree, and its city was immune from liability. In this case, under the law, the city would not be liable for these damages, so it's a recommendation of my office that this claim be disallowed.
Motion?
Move to disallow.
Second.
Looks like Ms. Jones have a quick question. Sorry. Ms. Jones, you have the floor?
Thank you. I just have one question. What if that happens and the city did inspect the tree for someone and the tree was said to be in good condition, but a storm came and the tree did fall, damaged the property, and inside it was basically rotten? What would happen in that case?
In that case, unless the city inspected, so in the case you presented, the city inspects the tree and observes no damage, but there's, essentially invisible issues in the interior of the tree that are not detectable at all by the external review and whatever other inspection criteria they use. The city would not be liable. The city's only liable in instances where damage is detected and the city then takes an excessive amount of time to mitigate those damages, or in this case, it would have been cut down the tree. So if the city had seen some damage back when it inspected it and then neglected to address the damage, then the city might have some liability. But until the city can, get X-ray vision and see through trees, we just have to go on what we can see and what inspections reveal as to the health of trees. And this was found to be a healthy one at the time of its last inspection.
Thank you very much, because it from what I'm gathering, the city is exempt from responsibility unless their forester determines that there is something wrong with the tree, regardless if it is or not. Am I correct in that?
Yes, if the forester finds a defect with the tree, then the city would have an obligation to correct that issue, whether it be, trim the tree, trim some branches from the tree, remove the tree altogether, depending on the defect detected.
But like I said, I just wanted to be clear, but if they find no defect and the tree does fall and it's clearly shown that it was rotten inside, the city still is not liable because the inspector didn't find the rotted tree inside. Is that accurate?
Correct. Yeah, that is accurate.
Thank you.
Alder Pete, you have the floor.
Thank you, sir. I understand and I support the disallowing, because what I'm hearing is that you can only make decisions based on what the evidence that you have, or in this case, what you can see. And you have to stop it there because of the way biology works, things can change. It could be termites or something eating it. So you have to draw the line somewhere. If it's not detected, then the city's liability has to stop someplace. It is what I'm understanding. Because since we don't have a crystal ball, I guess I could say.
Exactly,
Thank you.
Alder Pete.
Thank you.
Thank you, Alder Pete. President Tate, you have the floor.
Thank you. It wasn't noted in the or specified in the summary, but like, is this tree actually in city right of way, or is this on private property as well?
Yes, I apologize for not specifying that. It was on the city right away.
Okay.
That's why we got involved.
All right, because I wanted to clarify that too, because our conversation people, I think like, well, every tree is the city's responsibility. Like, no, they're not.
No, that's a good
I want
point.
to make sure this one wasn't. So, okay, thank you.
You, Chair Taft, you have the floor.
No, I was just going to add to Alder Jones' comments before, the city does have a duty to regularly inspect the trees. So I guess another scenario would be if the inspection had been, hadn't been inspected within a reasonable amount of time, right? That would be another scenario in which the city would be liable if we didn't meet our inspection obligations. But it would be very unlikely for a tree to be completely rotten or largely rotten without the forester being able to tell. But they do have a duty to inspect them on a regular basis. I don't know what that interval is right now, but I know the city forester takes it very seriously to make sure that they're all inspected within that time frame.
Thank you, Chair. Pete, you still have your hand raised. You have another question?
Sorry, I forgot to lower it. Thank you.
No problem. All right, at this time, I'll entertain that motion again.
Move to disallow.
Second.
All right, moved by Chair Taft and seconded by Alder Pete. All those in favor, say aye.
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 Aye. All those opposed? All right, motion carries. Item number 0746-21, communication sponsored by Alder Taft on behalf of the City Attorney's Office, submitting the claim of Roger McKinney and Lucy McKinney for consideration for disallowance. Staff recommendation that the claim be disallowed. You have the floor again.
Thank you, Alder West. This is the last one I've got for you tonight. Roger and this is another baseball hit from Horlick Field. Roger and Lucy McKinney, who reside at 1700 Blake Avenue in Racine, filed a claim with the city requesting $300 in damages that had allegedly occurred to their house caused by baseballs hit from Horlick Field. They do live adjacent to the field. This claim, it doesn't identify or assert, again, any of the individual baseball players who caused these damages were city employees. So the city is not liable for the actions of these individuals, or just non-city employees out playing baseball. For this reason, it is the suggestion of the city attorney's office that the claim be disallowed.
Thank you.
To disallow.
Second.
All right. Moved by President Tate, seconded by the chair. All those in favor, say aye.
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 All those opposed? Motion passes. Thank you, Marissa.
Thank you all.
All right, next Item 0748-21, communication sponsored by, wait, did I miss one? I did. I did. Let's back up. Sorry about that. Item 0743-21, communication sponsored by the Vice Chair on behalf of the City Attorney's Office submitting the claims of WH Coal Company for consideration for payment. Staff recommendation to approve payment of the submitted claim. Physical note, claim amount is $11,702.40. Funds are available in TID number 14, account number 40014-53500. All right, who will be speaking to this line item?
Hey, good evening. My name is Nicole Larson. I'm the new Deputy City Attorney, the new old Deputy City Attorney.
All right, welcome, Ms. Lockett.
It's nice to see both the old and new faces. It's great to be back. Thank you for having me tonight. So this is part of, and I'm not sure who's familiar with what, but if you have any questions, the WH Coal Company has litigation against the city. They appealed the acquisition of a portion of the Pew property down at 90 Reichert Court. The city had acquired that a strip of land, a strip of the Pew land, so that it could widen Reichert Court to a standard 60-foot right-of-way. And so when there are city acquisitions, there are certain costs that are allowable under relocation statutes and really mandatory under relocation statutes, because the relocation statutes really set a minimum for reimbursement of property owners and business owners. And so this claim tonight, it's two claims. It might be three claims, but the third one isn't so large. I found it tucked in with the other documents. The Pews submitted claims for $9,995 for the fence. The site that they have down there was fenced in. And so that fenced in portion included the part that the city acquired. And so that fence has to be moved. And so that portion is the $9,995 to install new fencing there, because it doesn't appear that you can use the old fencing and just move that. They also had, I believe it was 7 boats on the portion that was acquired by the city. And so the costs to move those boats were $1,707.40. And then the amount that I found tucked in was an $80 permit fee to install the fencing. Now, I don't know if they paid that permit fee, because I'm not sure what the status of the fencing is and if they ever got the permit. So I would want to verify that with the building department before we went ahead and issued payment for that. But I would ask that the claims for all 3 items be approved. So it would be the $11,782, and I believe it was 40 cents. And I'm happy to entertain any questions that you may have on any of those.
All right, Ms. Larson, you said the amount is $11,782?
Yes, yeah, that if that $80 was paid, then we would reimburse them that amount. If it was not paid, then we wouldn't reimburse them that amount.
Okay, gotcha. Any discussion? All right, Alder Pete, you have the floor.
Thank you, sir. Just for clarification for everyone, the city is obligated to pay for inconvenience expenses incurred by the Pews because of the acquisition. Is that correct?
That is correct. Yes, sir.
Thank you very much. Just want to make sure everybody understood what the issue was.
Yeah, both of those items are specifically allowed under the relocation statute in chapter 32.
Thank you. Appreciate your answer.
Sure thing.
Any other discussion? Seeing none, I'll entertain a motion right now.
I'll second it.
Move to disallow.
Can we have a motion to allow?
Yeah.
I'm so sorry. Motion to allow. I'm sorry. I'm so tired. Move to allow.
Thank you, Alderman.
Second, the motion to disallow or to allow. I'm sorry. We're
All
all
right.
tired.
All right, the motion on the floor is to allow by Chair Taft and seconded by Alder Pete. All right, all those in favor, say aye.
Aye.
All those
Aye.
opposed? All right, motion carries.
Thank you.
Thank you very much, Ms. Larson. Line item 0748-21, communication sponsored by Alder Taft on behalf of the city attorney requesting authorization for the city attorney's office to represent all city employees and officers in Wisconsin Voters Alliances versus City of Racine, Racine County case number 2021 CV 1231. Staff recommendation that the city attorney's office be authorized to represent all city employees and officers in Wisconsin Voters Alliance et al. Versus City of Racine et al. Racine County case number 2021 CV 1231. Fiscal note, employees and officers will be represented by outside counsel. Outside counsel will be paid from attorney professional services account number 11004-52100. Total fees are to be determined, sorry.
All right, back to me. So this is one of these instances I come to you when a City of Racine officer or employee is sued based upon actions allegedly taken in furtherance of their duties in their capacity as an officer or employee. This is such a case. This is an alleged public records law violation. So by law, when an officer or an employee is sued in their capacity as such an officer or employee, the city has a duty to defend. And if the city declines to defend, then the city would be required to pay for the defense of any such officer or employee. So that's one statute. Another statute says the Common Council may authorize the city attorney to defend any lawsuit such as this. So fulfilling my statutory responsibilities, I'm asking you for permission to defend officers and employees in this case.
Thank you, Attorney Litany. I entertain a motion.
Move to approve.
Second.
Second.
All right, moved by the chair, seconded by President Tate. All those in favor, say aye.
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 Those opposed? Motion carries. We have exhausted our agenda for tonight's meeting. Thank you, everyone, for your time and your patience. Meeting is adjourned. Be safe.
3 hours.
Thanks, everyone.
Thank you all again. Sorry for the delay. Have a great evening.
You too, Alder Pete.
Bye.
Thank you.